Hello, everyone, and welcome to the Healthy Living live stream. I'm your host, Dr. Andrew Kaufman. Today, I will be talking about a very important topic that may have slipped underneath your radar, which is medical consent forms. And this is critical for any situation that you are considering engaging the mainstream health system, because as you will learn, you may be giving up many of your rights. But first, let me announce a brand new offering, a law workshop, which is why today's topic is law related, called It's Not Your Duty to Pay. And this will be available on my websites. The link will be posted during this live stream, and it's just launching today. And this is a very, very exciting workshop because I will teach you the very basics with respect to exactly who you are in the law, what your job is, and why you have no liability to debtors. So this can appeal to you in many situations in law and finance. So please take a look at that. Okay. For today's topic of medical consents, you have to, of course, read each consent form individually because there may be differences. And of course, from country to country, there may be additional differences, but I'm going to go through a consent form today. But I'll start off first by giving you a little background on contract law. And at the end, I will give you various ways that you can obtain remedy for this situation so that you don't agree to anything that you don't intend to. So I'm going to bring up a slideshow here. And I apologize that we're going to have to actually look at some slides with just words. But when you study or teach about law issues, language is the most important thing. So here, I'm just showing you that there are various different types of contracts that you'll be asked to sign or accept when you present for medical treatment in a hospital, an ER, an urgent care clinic, even a private medical office. And sometimes these will be separate forms and sometimes they'll be on one form. And this includes a financial contract, a contract for your medical treatment, and also for disclosure of personal health information. And there may even be additional contracts included in these documents. So I want to go over what the basic elements of a contract are so you know how you can engage in this process and basically change things so that the terms are agreeable to you. So the basic 6 elements of a contract include the offer. So the offer is what's on this consent form as presented to you. Is they're offering you all of the terms of the contract written on that paper. And then your acceptance would be you reviewing that, agreeing to the terms, and then signing it. Now, of course, you don't have to accept it if you don't agree with the terms of the offer. You can make what's called a counteroffer. And that comes into the next element, the awareness section. So there has to be awareness by both parties of the terms of the offer. And sometimes this is referred to as a meeting of the minds. So there could be a back and forth discussion to negotiate the terms. So this can include, of course, a counteroffer where you can actually write in modifications right on that contract form and then indicate your acceptance and send it back to them for their acceptance. And it also could mean that if awareness is impaired for some reason, like, for example, you're unconscious, your mental acuity is affected by your health condition, or the situation is under duress, and I'll explain a little bit more about that these elements may invalidate the contract because you were not fully aware. Consideration is the next element. So each party must offer some form of consideration. Of course, this could be financial. It could be providing a service. It could even be protection from liability or something else. So there has to be some benefit for each party in entering the contract. Obviously, with a medical consent form, the benefit for the medical provider would be financial, and the benefit for you would be to receive some form of diagnostic or treatment procedures. The next element, capacity. The parties have to have the capacity to enter into a contract. Now, this doesn't mean they have to be competent adults necessarily, but they have to be able to demonstrate the capacity, to understand the terms of the contract and to be able to comply with actually carrying out the contract. And then lastly, the legality. So you can't have a contract for acts that are in violation of the law. So for example, a murder for hire contract would not be enforceable on its face because the provisions of the contract are against the law. So I think you get the basic idea, and most of this is really common sense. It's simply that we neglect to exercise our own participation in this contract process by just simply signing, and usually without even fully reading. So since these contracts are with a corporation, right? Because almost all of these hospitals and even medical practices will be incorporated into some sort of business structure. And there is financial consideration being exchanged. That puts this in the jurisdiction of commerce. So the Uniform Commercial Code, which is adopted by each of the 50 states, and there may be some slight differences from state to state, would be governing this contract process. And also the elements that are discussed in the UCC are part of general contract law, as sometimes mentioned that way. So here we have section 1-103 of the UCC. And I will direct your attention to paragraph B, where it says, unless displaced by the particular provisions of the UCC, so in other words, unless there's a special exception, the principles of law and equity really refers to fairness between the parties, including the law merchant, which is a form of commercial law, and the law relative to capacity to contract. Remember, I said capacity was one of those 6 elements. Principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating cause supplement its provisions. So in other words, these duress, coercion, mistake would be invalidating to a contract. So if you enter into this contract under duress, it actually becomes invalid or invalidatable. Now, I want to look at the bottom of this slide first. This is UCC section 1-304, obligation of good faith, which says every contract or duty within the UCC imposes an obligation of good faith in its performance and enforcement. And good faith means honesty in fact and the observance of reasonable commercial standards of fair dealing. So this is similar to what I mentioned about equity, that there has to be an element of fairness or good faith in every contract. And if we look at the top of this slide, UCC 1-308, something that everyone should be familiar with if you're going to ever enter into a contract, that a party that with explicit reservation of rights performs or promises performance or assents to performance in a manner demanded or offered by the other party does not thereby prejudice the rights reserved. So that means that if you specifically reference this law or put the appropriate language, that whatever you sign to in the contract, you're not giving up any of your rights. right? And we're talking about the rights that are protected by the Constitution, for example. And you can denote this by simply writing all rights reserved, or I reserve all rights. You can reference UCC 1-308 specifically, or you could write without prejudice, or under protest. Now, under protest is something that would apply to a situation of duress. But you simply write these words right next to your signature. I would encourage you even to take a quick photograph of that on the document in case the document is altered illegally in the future. Now, this takes us to the part of my presentation where I'm going to go over a specific consent form. And I found the consent form from the Mayo Clinic. And interestingly, I was just looking for an image of the Mayo Clinic's symbol. And this article came up from CNN. Mayo Clinic accused of placing academic freedom in jeopardy after suspending physician who criticized U.S. agency during pandemic. So it tells you a little bit about the ethics of the Mayo Clinic, that they want to essentially get rid of anyone who doesn't adopt the party line that they adopt. And we'll see if that type of ethics plays out in this consent form. Now, notice this is a one-page form, but it's very condensed. So what I've done is taken some sections out so we can look at them in a bigger font. So this is the first and perhaps the most important section, the authorization for treatment. And we're going to read through this, and I'm going to make some comments line by line. So first, the first sentence: I consent to the rendering of medical care, which may include routine diagnostic procedures and such medical treatment as my attending physician or physicians or other Mayo Clinic medical staff consider to be necessary. So let's dissect that sentence a little bit. So I consent to the rendering of medical care. Notice that's a general term and doesn't apply to, a specific test or a specific procedure, but encompasses all medical care. And it says that it can include routine diagnostic procedures, but also such medical treatment as my attendings consider to be necessary. So in other words, anything they think is necessary, you're giving permission for them to do. So, and this could be even unrelated to the reason why you sought care. Let's say that you go to the Mayo Clinic to get a second opinion about migraine headaches. Well, they may think it's necessary for you to be screened for various quote unquote infectious diseases, and will just make the decision to test you without even telling you what they're doing. Perhaps a nurse may just come in and start to collect a sample and you don't even know what's going on. Now, I also want to draw your attention to the little asterisk about the Mayo Clinic medical staff, because at the bottom of the form, it explains what that means. And what it means is anyone who either works or is affiliated with the Mayo Clinic, including any employees, that could even be, a janitor, business associates, and agents. Agent is someone who represents another entity, like someone who represents the Mayo Clinic and has the authority to sign on their behalf. So in other words, you're letting a lot of different parties make decisions about what's medically necessary to you, even people who aren't actually health professionals. Now let's read on. I may be offered medical services via telemedicine systems that involve the delivery of healthcare by electronic communication with a provider who is at a different physical location. I consent to initiating and/or receiving technology-based communications with my providers, including consulting services from a specialist performed virtually. So in other words, you're agreeing to have virtual consultants, doctors at other locations, be involved in your case, even if they're not there physically and can't perform a physical exam on you personally. So you may or may not want to agree to that. I agree to be responsible for any charges that insurance does not pay. Now, it's interesting they put this here because they have a separate section on that I'll get to. But one thing that's important about this is that they don't say how much that's going to be. All right, here, I understand that my medical care and treatment may be provided by physicians, including fellows and residents, medical and allied health students, physician assistants, nurses, and other healthcare providers. So many of those are students or trainees, and you're agreeing that students and trainees can provide your health care, but it doesn't say here anything about specific supervision or guidelines. And then you say, I've read and understand this authorization and understand that no guarantee or assurance has been made as to the results that may be obtained. In other words, I could die, and I'm not guaranteed to have any outcomes. Okay, so think about if this is something that you really want to or intend to agree to when you seek hospital treatment. Now, here is another section, the authorization to use and disclose medical information. And let's look at the bottom here, these two asterisks. Medical information includes, but is not limited to. So in other words, it can include more than what's stated here. Photographs taken for identification purposes. So you're agreeing to share pictures of you, which can be used for identification. Information related to psychiatric. So in other words, if you have mental problems, that's going to be included in this section. Sickle cell anemia, HIV/AIDS, communicable diseases, genetic testing, and alcohol and drug abuse diagnosis and treatment. So anything that you might consider especially private, you're agreeing to disclose in this section. So we'll read on. I consent that as a Mayo patient, my medical information will be used, processed, and disclosed in accordance with U.S. law and as outlined by their notice of privacy practices. And you authorize them to use, process, or disclose medical information and for the following list of purposes: to provide me with treatment and to coordinate my care. Now, I don't think too many people would disagree with that, because you're going to have, maybe different doctors, nurses. You want them all to be able to share the information about your case in order to take care of you. However, when we go on, we say to bill for and collect payment for services, which may include communications to my payer and billing addressee guarantor. So your insurance company is going to know all the details about your health information, including if you have any drug or alcohol abuse, if you have psychiatric problems, etc. For healthcare operations as described in the Mayo Clinic Notice of Privacy Practices. Now, I'm not sure how it could help, but that may be like quality improvement, things like that. For Mayo and my insurer to share my past, current, and future health, treatment, and account records about services I receive from Mayo and other care providers as needed to manage and coordinate my care and improve the quality of that care. So really, it's about improving the quality of collecting any bills that are due and finances, and to accrediting and quality organizations, regulatory agencies, and public health reporting agencies. So this could be like for infectious diseases, or it could be just collecting outcome data for various regulatory agencies. And lastly, where they give you an option to opt out, to participate in the health record locator services information exchanges. And that's something for a variety of different hospitals and healthcare providers to share information through an electronic database rather than printing out records and bringing them physically from one place to another. And they do give you the option to opt out of that if you so desire. So this is what you're agreeing to being shared in terms of your personal and private information. And now the next section, a very important two sections here to review, is one, the statement of financial responsibility, and then secondly, dispute resolutions. So for financial responsibility, it says here, I acknowledge I'm responsible for all charges for services provided, including any amount not paid by my healthcare plan or an out-of-state workers' compensation payer other than billing terms and restrictions under a government program or as prescribed by law in the state where medical services are provided. So in other words, you're agreeing to pay any amount. Your insurance could deny coverage for all of the treatment that you get, and you're agreeing that you'll pay whatever services are provided and whatever the amount is. Now, I would say that this actually is unenforceable on its face because there is no specific consideration that's being described here. It's an amount that could be almost anything, could be millions of dollars. And in some cases, I'm sure it gets close to that amount. Now, if I read on, I authorize Mayo to apply any credit balance on my account to any amounts that I may owe one or more Mayo entities. I agree that Mayo may obtain financial information, including consumer credit reports, to determine eligibility for financial assistance and or payment options. So you're agreeing for them to review your credit history, and then that will lead them to make decisions about how to pursue collections possibly. Information on financial assistance is available, blah, blah, blah. So I think you can see that this can get you into a big financial disaster, depending on how much they say that you might owe in the end. And if we look at overall what happens with health care bills, that it's one of the leading causes of bankruptcy in the United States. Now, this section on dispute resolution, I wanted to bring up here because you're basically lowering the legal costs for the Mayo Clinic by agreeing to this. So I agree that any dispute related to healthcare services rendered by Mayo is subject to the exclusive jurisdiction of the appropriate court in the state where the provider of the disputed services is physically located when the services are rendered and the law of that state. So in other words, if you go to the Mayo Clinic in Rochester and receive services there, and then you sue them for malpractice or some other tort, you basically have to sue them in Rochester, Minnesota. And they are a big taxpayer to that local municipality, and I'm sure that the court system would have a bias toward the Mayo Clinic because they're a huge, important part of that community. Plus, this prevents the Mayo from having to, hire attorneys that know the law in another state or travel, have the travel expenses for depositions and trial, and et cetera, et cetera. So it definitely favors the Mayo Clinic. And then lastly, at the signature line, it lists this language: attention, this is a legal document. Okay, it is a contract, as I explained, although many people may not consider it that way. Changes will not be accepted on this form. Now, that's quite interesting. And I'm not sure that that's actually legal, but you could just cross out that line. And in fact, you can cross out any line on these consent forms and write in additional language. I would suggest that you at least initial anything that you cross out to authenticate that it was you who did that, and make a copy or take photographs of the altered document. Now, here it says questions or requests for alterations must be made by calling this number. And I think that it would be a good idea to do that, even if you're going to cross out this section, and document that you made that call and who you spoke to, because that is a demonstration of awareness of the other party that you are modifying this contract or making a counter offer. I'll read on. By signing, I agree that I understand and accept the terms on this form. I understand I have the right to revoke the authorizations on this form at any time by notifying Mayo in writing, except to the extent that Mayo has already taken action in reliance upon them. So if you sign this form and then the Mayo Clinic provides some treatment that they say is necessary, you can't go back and undo that or fault them for it unless you've already revoked this contract. Now, it says these authorizations will remain valid until I revoke them in writing. So you can't revoke it with a phone call or an email. You have to actually write a letter to them revoking this contract if you signed it originally. And if you don't, it will remain valid till the end of time. So let's say that, you go there for some treatment, you signed this, then 10 years later, you have another reason to go there. This is still valid. So unless you revoke it. So you have to be very, very careful to make sure what you have on file. And this is pretty standard in medical consent forms that I've seen, that they remain valid until revoked in writing. Okay, so I want to give you some remedies and how you can deal with this situation. So if you're unable to modify the contract, but you are in a situation that is urgent and you need to get the treatment that you came there for, you can sign it and note that it's under duress or under protest. And this will make it invalid. Now, you don't have to do like the example here and sign across the whole document. You can do it on the signature line, and then you will be able to invalidate this contract in a court of law subsequently because you signed it that way. So in a pinch, that is one of the best things to do. Now, if you plan ahead, there you have other options. So here are two options that you can have these documents ahead of time. One is a living will. A living will is when you make healthcare decisions for yourself in the event that you're unable to make them in real time. So you think about, if you're incapacitated, what would you want or not want? And you can list those things out in as much detail as you want. And you can do many things with this document. You can actually, file and record it with the county. You can file it with the hospital in advance, or you can appoint someone to deliver it to the hospital. You can, carry it on you. There are many things you can do to make sure that the hospital receives this and that it guides your care. Now, the second option is a healthcare power of attorney, sometimes also called a healthcare proxy. And I would actually advise you to have, if you're planning ahead, you should have both of these documents available because it provides you more flexibility. Now, this healthcare power of attorney is when you designate someone else to make decisions on your behalf if you should become incapacitated. It's, of course, important to choose someone that you trust and someone that's going to respect your wishes about care. So you don't want to choose someone who would just say yes to anything. But you can also have this document prepared in advance, and you can keep some emergency contact information on you, like in your wallet or your purse, that if you're unconscious, someone can find and contact your power of attorney for you. And then lastly, I wanted to provide you with some language that you could actually write on their consent form. You can like turn over to the back and sign it and cross out a bunch of things that are written in their original contract. And so you may want to take a screenshot of this right now. I'll leave it up for a couple of minutes as I discuss it. But this is just some language that I put that counteracts the language that I find disagreeable. Now, it doesn't cover the financial aspects, but you could see how you can write up something very similar to that. So, for example, you could write that you agree to be financially responsible up to a limit, right? Let's say up to $500 or up to $1,000. You could also say that you don't agree, that you reserve the right to negotiate the price and when it's presented to you. So there are many ways you could approach that. But in terms of the treatment and the disclosure of information, this is some language that I feel is pretty strong. So I'll read it. I will make my own decisions about each and every specific diagnostic and/or therapeutic procedure on a case-by-case basis. So anything that they want to do, I want to hear about the risks and benefits, and then make a decision for that specific procedure, even if it's just drawing my blood to get a blood count and a chemistry panel. I still want to be able to make that decision on a case-by-case basis. I do not consent to or authorize any physician, health professional, student, trainee, staff, or agent of whatever hospital to conduct any medical procedures of any kind without my expressed agreement. So in other words, I'm not giving them carte blanche to do anything that they deem necessary. I'm saying I have to express my agreement for each thing. Expression would be either verbally or in writing. So in other words, it's not implied. There's no assent, right? My silence is not consent. It has to be expressed. Either I say, yes, please do that, or I write down, I agree to such and such. I'll go on. I do not consent to any procedure except for history taking, which is asking me questions. I do not consent to any physical examination, pharmaceutical drugs, vaccinations, laboratory studies, bedside or other non-surgical procedures, surgery, imaging studies, or other interventions. So I listed out general categories, but also made it general to cover really anything. And then I talk about disclosure. I do not consent to sharing my personal health information with any parties aside from my immediate health providers. I reserve all rights to make healthcare decisions independently and provide informed consent according to my will and timeline. I will provide or refuse consent for each and every proposed medical procedure, diagnostic or therapeutic, on a case-by-case basis. So I add some redundancy in there to make sure the point gets across. I also put a statement on liability here. If you administer any diagnostic or therapeutic intervention without my express consent, you will be held liable for any and all damages, civil and criminal, I may incur. And then the last part is I actually designate a healthcare proxy or power of attorney in case I'm incapacitated. So it's sort of built in there. And I can, carry this language with me if I like. To use for this purpose, or keep it in a safe place that I can access it. Maybe, just have it on my phone, and you can handwrite this, or similar language right on the forms that they give you. And this will really provide quite a bit of attention. Now, if you have difficulty with this, I suggest that you talk to the risk management officer for the hospital, which is an attorney that represents the hospital interests and will be concerned about the hospital's liability. And you can discuss this in more detail with them. And that they should be able to facilitate all this working very smoothly. If they're unavailable, of course, you should talk to someone in the hospital administration, like, for example, the nursing supervisor, the director of nursing, or other administration of the hospital. All right, so I hope that was a very helpful analysis and has helped you realize that you could get into quite a bit of trouble just blankly signing these forms. And of course, I've known several people who have experienced just that. So always read what you're proposed to sign and realize that you have the power to accept or counteroffer or reject. All right. I would have a few minutes now to take some questions before we wrap up today's live stream. So Scott, if you want to place those on the screen for me. Okay, great. So Ben asks, we didn't complete their whole schedule. So far, no effects. How do we decline the ones right after birth? I'm not really sure I understand this question. So maybe we should go to the next question. Ben, perhaps you can clarify a little bit and I'll get back to you. Okay, looks like we have some clarification. Hey, doctor, the wife is due in January with our third one. First two are 13 and 10 now, and we weren't fully aware about vaccine effects back then, but we got lucky and she breastfed for almost 3 years each. And so I think we didn't complete their whole schedule, no effects. How do we decline the ones right after birth? Well, this would incur, several different things. So one thing is, and I didn't, specifically talk about prenatal or maternity care, but they have, consent forms that specify that you actually give up guardianship of the newborn baby while you're in the hospital. So you want to prevent that. So one thing to strongly consider is having a home birth. Then it's much easier to control these elements. But it really comes down to, two things. One is the forms that you sign, that you make sure you read carefully and don't give up any rights, so that you can specify that you don't want these interventions after birth. You should also discuss it with your provider ahead of time. So if you're working with an obstetrician at that facility, let them know in advance, make sure that they will uphold your wishes, because not all will, but there probably are birthing centers or places that are more willing to work with you. And then when you're actually in the hospital after the baby's born, you have to watch like a hawk, because even if you worked everything out ahead of time, they are so used to just doing this, procedure ABC, that a nurse might come in with a syringe and, inject the baby before you even know it. So never take your eyes off the baby until you leave the hospital. All right. Do we have any additional questions? All right. So it looks like that will be it for today. But let me remind everyone that I am announcing a new law workshop. It is Not Your Duty to Pay, which will be a really excellent educational experience. Starting off with, the basic information of who you really are, what you're supposed to be doing, why it's not your duty to pay, and that you actually have no liability. So this is a way that we can realize our true abundance and learn how this system, although it seems to be working against us in every way, is actually set up for our benefit. But we have the challenge of maturing and becoming, fully competent, so that we understand the system and how to utilize it for the benefits that it was created for our purposes. And I'm going to explain all of this, and including, what the birth certificate is, how this all was set up, and then how we can utilize it even to stop a lawsuit against us dead in its tracks, in just a few easy steps. So please do check out this exciting upcoming workshop. And as always, I will see you next Wednesday for another Healthy Living live stream. Until then.